Hi, my name is Robert Chelle with Chelle Law, and my law firm assists professionals with employment contract issues. Today I'm going to talk about, can an employee terminate an employment contract? The short answer is obviously yes. However, it's going to be dictated based upon what the terms in the contract say. So in any employment contract, there's going to be a section that deals with the terms, meaning the length of the contract, and then also termination, so how that contract ends. So let's first talk about the term of the contract. So most contracts will have a date, so meaning it's a year long, 2 years, 3 years, and then they'll also have language that states if the contract isn't terminated, it'll just automatically renew for successive 1-year terms. So in that case, if the contract isn't terminated by another way, after the initial term ends, it'll just continue on forever until terminated. I would say rarely is there a fixed term with no language about automatic termination. So if it was just a 2-year fixed term, no automatic renewal, it would just end at the end of 2 years, and that would be it. The parties can go their own way. Now, as far as terminating the contract, the first part is just if there is no renewal, it just ends, the contract's terminated. Second, by mutual agreement. So if the employer and the employee agree the relationship isn't working, you can always, by agreement, decide to just move on, and then that's it. You can move on. Next would be for-cause termination. So in this case, this would be if someone breached the contract. So there'll be language in the contract that states all of the reasons why the employer can fire the employee, so the professional. And obvious things, if you need a license to perform the activity and you lose the license, if insurance is required and you're uninsurable, usually there's some kind of I guess vague behavioral clauses. If you're disabled, you die. Obviously the kind of standard things, but then there also should be a part that's called a cure. And so in that case, if one of the parties believes the other party's in breach of contract, the most common is just payment concerns. Either someone's not being paid, either the amount that they were promised in the contract, or maybe the timing of the payment, or if there's a bonus involved and there's some kind of disagreement over how much the professional is owed. That's always a big, reason why there would be some kind of allegation of breach of contract. But in this case, if you believe the employer was in breach of contract, you'd have to provide them with written notice. And then the cure period simply means the employer would then have a period of time to fix whatever the breach of contract is. So normally that's somewhere between 15 to 30 days. And the same can go for the employee. So if the employer thinks the employee is in breach of contract, they give them written notice, and then the employee has 15 to 30 days to fix the breach. If the breach is not fixed, meaning the other party still believes the other party is in breach, then usually that party wouldn't have the option to immediately terminate the agreement. Now, the last and most common way is without cause termination. So in most employment contracts, there'll be some kind of language that states that either party can terminate the agreement at any time for any reason with a certain amount of notice to the other party. So normally it would be somewhere between 30 to 90 days. And so in that scenario, if the professional is unhappy, they want to move on, they give written notice saying I'm utilizing the without cause termination notice in the contract, then they have to work out whatever 30, 60, 90 days. And then at the end of that period, they can move on without any concerns as far as terminating the contract. So yes, an employee can terminate an employment contract, but they have to follow the terms of the agreement. Now, just because an employee terminates the contract doesn't mean it necessarily completely ends at that point. So there could be things that are required of the employee if they terminate the contract. So many times if a signing bonus is given, relocation assistance is given, then the employee would have to pay back some kind of prorated portion of that if they left within the initial term of the agreement. Others could have some kind of non-compete associated with it. So just because an employee terminates the contract doesn't mean that the non-compete doesn't apply. It does, or at least it does in most circumstances. If you're in a state where non-competes are enforceable. So if there is some kind of, geographic restriction and then some kind of temporal restriction, how long it lasts, that will continue on even if the employee terminates the contract. If some kind of malpractice insurance is involved and tail insurance is needed, it will say in the contract who has to pay for that. So if the employee terminates the agreement, they may be responsible for that as well. So although the employee has options to terminate the agreement, it doesn't mean that there aren't at least some strings attached to that. I would suggest really one of the highest priority things that I look at in a contract when I'm going over it with a professional is, all right, how do you get out of the agreement? And then what do you have to do if it ends within a certain period of time? And that way, the employee can know, all right, well, I need to set aside this amount of money if I have to pay for tail insurance or if I have to pay back signing bonus. So they're important discussions to have and certainly things that can be negotiated in advance of signing any kind of employment agreement. So hopefully that was helpful, kind of a little overview of termination of an employment contract. If you have any questions, you can always call us at the phone number listed below in the description. Or you can always reach us through our website, chellelaw.com. That's CHELLE law.com. And I appreciate you watching the video. Thanks.